If you have a credit card, or say cable TV, or a cell phone, or even a job, it is pretty likely that you have given up a fundamental right, constitutional right, without even being aware of it. The right to go to court if something goes wrong. Now, this week in the New York Times, they're really peeling back a practice that my next guest calls unbelievably unfair. Democratic Senator Al Franken has spent much of his 6+ years in Washington fighting clauses like this one from the American Express Terms of Service, and I will quote Senator Franken, you or we may elect to resolve any claim by individual arbitration. Arbitration being a private, secret, binding alternative to lawsuits. An individual meaning the person who agrees, all by yourself. No banding together with other plaintiffs in so-called class action lawsuits. Amex is far from alone in this practice. All of these companies and many more have made sure that they will never have to face an angry customer, or worse, thousands and thousands of angry customers in a courtroom facing down a judge. Look at all those logos. You probably consume something in that list. And Senator Franken thinks there ought to be some regulations about this kind of alternative system of justice. Senator Franken, thanks for being here. Appreciate this.
Thank you for your lead in on that and describing what the situation is. This is also in employment contracts, in a contract with a school where you thought you were signing up for a course where you get an accreditation and get a job afterwards, but it turns out you don't. This is a way in which the deck is stacked. The system is rigged against the little guy when these corporations make you go to arbitration, and the arbitrator is chosen by the company.
So, I think a lot of people agree with you. People get very frustrated when they realize that that's what this means. But it always comes down to you hold the keys as the consumer. You check the box. You say next online when you agree to the service. You're the person who ultimately makes the agreement. And a lot of those who support arbitration say you can always opt out.
You can't really. These are what are called contracts of adhesion, which is basically it's one very powerful entity against you. And let's say you only have one opportunity to get internet in your community, internet broadband with, say, Time Warner Cable. Well, Time Warner Cable then can start charging you without telling you at any point. They can just put $40 more on because of the modem that was there when you signed the contract. I'm saying this because this has happened.
Yeah.
And you have to go to arbitration with them for $40. And that's you don't want it, or you could go in a class action suit if you could, but they won't allow you to do that. And so a class action suit would be 1 million Time Warner Cable customers banding together saying, don't charge us $40 a month for this modem. And that is a way to get justice. But all this is now closed off to consumers, to employees, to students in all of these contracts. And also, it's when you check off terms and conditions, this is literally the fine print in these contracts.
Well, and it's a lot of fine print, and I honestly don't know anyone who has ever read through it before clicking the next or signing off on it. But I do want to ask you this. Those who support arbitration say it does have its benefits. You limit the personal injury ambulance chasers out there. You get some fair and efficient settlements. Some people certainly say that they've gotten fair and efficient settlements. And you do.
Some people
sort of
say that, and mainly it's the companies.
Some do. Mainly the companies. I will give you that. The benefit has definitely in the statistics shown that they have gone to the companies. But in the meantime,
let me explain something. They pick the arbitrator.
Yeah.
And it's been shown that the arbitrators, in order to get hired again by the company, decide more often for the business. So this
the statistics prove you out. You're absolutely right.
And I've gotten this under testimony. I've had hearings on this, and I've had even representatives of the pro-mandatory arbitration, pre-dispute. That means before anything bad happens, but when you sign your contract, you sign this thing, who have written that arbitrators will want to get a pro-business reputation so they get jobs.
Well,
and so they will decide for the, and if you read the New York Times series, you'll see that in spades.
They've interviewed some. Some have actually said that they were worried about losing business because they're not going to get business from Ashley Banfield if I'm the little peon that goes into arbitration, but they are going to get business, repeat business from the company that might go up against me. But let me ask you this. You have raised the legislation a few times. The Supreme Court has ruled on this twice. What is the solution to it?
On a 5-4 basis. Well,
yeah,
the solution right now, we've had some Republicans who have voted for getting rid of certain arbitration clauses and certain things. So that's part of the hope. Secondly, the Consumer Financial Protection Board is making some rules on this. So is CMS, which oversees Medicare and Medicaid, and they're doing it on nursing homes. We've seen some terrible things where people die in nursing homes, and their children have to go to arbitration, and it really doesn't matter what the facts are. They decide for the nursing home. And so there are regulations being promulgated both in CMS and in the CFPB, which I think are maybe very helpful.
So it would be irresponsible of me if I didn't ask you a question, a couple of different questions about the current state of presidential politics.
Sure.